morning, everyone. Still morning here. My name is Tammy Welch. I'm the president and CEO here at the Arvada Chamber. Welcome to employment law. I know this is a really important topic for many of us, and so we're grateful that you took time out of your busy schedules to be here and learn with us and an incredible presenter that we've worked with for a number of years. I want to thank and recognize our friends from Arvada Economic Development Association. Nancy and Sarah are here. They have co-hosted this event with us today, just to make sure that you all have this important information. As you heard, it is being recorded. I will stop it when we get to the Q&A part of everything today, so you can feel free to ask questions without them being on the record if there's any concerns with that. So know that we'll handle that way. I do want to note on your chairs, you all have these little cards that say join our network. So part of what we do here at the Arvada Chamber is education, as well as activation and engagement across a variety of different events and opportunities. So if any of the items that are listed here, advocacy, talent, housing, childcare, entrepreneurship, or inclusion and belonging, are things you're interested in getting updates on, just fill out this little card, and then on your way out, there's a glass bowl. Drop it in there for us, and we will make sure that you're getting updates on the things that matter most to you. So with that, I will introduce us to the guest speaker today, who's absolutely outstanding. Chuck, I'm gonna do it. Passaglia.
Very good.
Okay. He's an employment attorney and the founder of Employment Law Solutions, LLC, which specializes in workplace investigations and training the entire workforce in critical employment law compliance matters, including harassment and violence prevention, wage and hour rules, managing employees' absences, and protections under the anti-discrimination laws. He's also an adjunct professor at Regis University in Denver, graduated from St. Louis University, a Jesuit college in St. Louis, Missouri, with a BA, magna cum laude, in philosophy. He received his law degree from University of Denver College of Law, where he served on the board of editors of the Denver University Law Review. Please join me in welcoming Chuck.
Thank you, Tammy. Everybody, good to see you. First, I'm gonna just make sure I can click these slides ahead. Hold on for 1 second. See if we can do this. Oh, Tammy, what do I do here?
All right.
It's working there.
All right, give it a go now. There we go.
Perfect.
All right.
First, I so much appreciate Tammy for allowing me to do this and Arvada Economic Development Council. So can we dispense with all formality and just talk among friends about how work works? So just a couple things for success. Our time is limited, but I'm gonna make sure I get your needs met. You can ask any questions as we go. I know that you all represent a wide variety of businesses. So can I just assume that no one knows anything that we're going to talk about here when it comes to the law of the workplace? So there's no such thing as a bad question. Trust me in this area. It's complex. We're literally started this week a new presidential administration, which has essentially changed the entirety of my slide deck, just so you know. And so we'll talk about that. So I like to lean into what to expect about work this year, but we're also going to talk about Colorado. Colorado is an entirely different set of rules, substantially more employee-friendly jurisdiction. And so there's a tension about what the federal government really expects of the workplace and what to expect in the future, and really what Colorado expects of the workplace, which is in many ways entirely different. The other thing is I'm in an outrageously good mood. And so that's good for you because I talk extraordinarily quickly. I have a mountain of slides to go through. And can I just say, I'm not going to talk about every one of them in any substantial detail. That's why I appreciate Cami making the slides available to you. You can reach out and call me or send me an email after the program if you have any questions. People commonly do that. They always ask me, wait, you're a lawyer. What do you charge for that? Zero if you showed up in this room. And so we're allowed to have a continuing conversation about any of the content of the class. Just know that. I think it's important that you have that understanding. It's really for you to learn a little bit more about how work works and not to really feel like you have to know everything in less than an hour on this topic area. The other thing is there's just a dizzying amount of information. People always look at me and go, man, it's just too much. I would recommend you really focus in on things that might be relevant to your business and that might be most helpful, because I skim the entire wave tops of this area. So it is about a mile wide and an inch deep. And so you just want to focus on those things that might be relevant to you, could help you out considerably. Don't get way down in the weeds here because I talk about a lot of our rules in Colorado you may have never heard of. But I want to be clear, it may matter depending on the size of your business that you do or do not have to follow them. So let's talk about work. And that is, the Trump administration. So obviously on Monday, we have a change of our government, yet another transition of our government. And so immediately I have to say, as I mentioned earlier, that already the Trump administration has done some of what I want to talk about. So the first thing is, the issue of DEI. This is a controversial topic for many people. I should share with you, I really don't care who the president is. I teach what I do in an apolitical sense. I practice for employers. I don't really care what their employees or their business politics are. A lot of people are frustrated with me that I don't take strong political stands. It's just not what I do. I really just work for work. And will there always be changes of administration, and do they affect how work works? So if you're looking for some standing on a podium to give my political views, just isn't going to happen. Let me talk about what to expect from the Trump administration, though, for the first 5-10 minutes here, because it's going to be relevant to how businesses, even here in Colorado, work. So the first one is the attack on DEI. It's already happened. Trump administration immediately yesterday issued a sweeping executive order, which essentially attacks DEI initiatives. This may be irrelevant to you, but it's really not, because as part of that DEI initiative, not only is this an effort to close federal efforts at diversity, equity, and inclusion, but there is a statement in there that the federal government will scrutinize private employers' DEI programs. I should share with you, remember I said I don't tell you my politics. I am a fan of DEI programs. I'll share this with you and I'll tell you why. Because, and I don't care what your politics are in this regard, nobody is against inclusion, at least in this country. And certainly everyone understands that our state, our country is becoming extraordinarily more diverse. So most people get the importance of diversity and inclusion efforts in recruiting and retaining well-qualified people to work for the future of your business. Just so you know, the one that draws a lot of the controversy is this, and that is equity. It's the one that starts to get people animated about these issues because some people hear equity, which is a conscientious effort to remove barriers that keep people from feeling included. Some people hear it as a preference or favoritism, which, by the way, is unlawful to extend anyone a preference on the basis of any protected category, and has long been against the law to extend a preference. But a lot of people get wrapped around the axle on that term, and you should know it. So if you have DEI programs, there's nothing unlawful about them, but they will be scrutinized to determine whether you wittingly or unwittingly are engineering a preference for any protected group. Make sense? Next one is Pregnant Workers Fairness Act. This one is controversial too. And so I just read today that yesterday, President Trump appointed Andrea Lucas to be the new commissioner of the EEOC. That may mean nothing to you, but Andrea Lucas is relevant because she was the principal opponent to some of these rules that were extended last year. Let me explain this to you. Can we have hard conversations in these classes? So I'm just going to do this quickly because I'm a blunt speaker and no one gets hurt in my programs, but I'm going to say this. This covers all of you, just so you're aware. Interestingly enough, Colorado already has this rule. Welcome, come on in and have a seat. Everyone in Colorado and under federal law has a legal responsibility. By the way, this is everyone in the room. I don't care if you have 5 people in your business or you have 500 people in your business. As a matter of state law, we have to accommodate pregnant workers. It's a fundamental legal requirement in the state of Colorado. Why does it draw any controversy? Because most people favor the accommodation of pregnant workers. You probably are well aware, 85% of women who work will become pregnant during the course of their working life. It's not uncommon that women will have children while working. So everyone understands the importance of accommodating this particular group. These rules drew some controversy, especially from now Commissioner Lucas, because not only do you have to accommodate the condition of pregnancy, but also any pregnancy related condition all the way through childbirth. Why does that draw any political controversy? Because, here's the blunt speak, because aspects of pregnancy that draw controversy, primarily for religious reasons. So for example, you're aware of the debate about people who are incapable of becoming pregnant and use means to become pregnant, either IVF or people who sadly lose involuntarily a child. They miscarry a child and have needs associated with that, psychological or physical. And then finally, the more controversial issue there is someone who voluntarily terminates a pregnancy, aborts a fetus. All of those controversial topics are swept within this protection. Commissioner Lucas wants to be clear. Some people may raise religious objections to these issues because they don't share in the view that people should be accommodated or necessarily not discriminated against for choosing these different aspects of their pregnancy. What do you need to know? Colorado law is still clear on this. You have to protect people at all phases of their pregnancy, and I'm going to make sure you know that, even though the federal government may even end or alter these rules, and they're likely to do so. That goes to the next issue. I saw yesterday that the Trump administration came out with a brand new executive order, which makes it very clear that in the eyes of the Trump administration, the term gender is exclusively defined as male or female. It reinforces, and again, you can ask any questions about this. It's important for your understanding. This is a common view that gender is exclusively a binary biological event. You're either a man or a woman, XX or XY on the chromosomal spectrum, and there is no other consideration of gender. What's intriguing about that is this issue, and that is the federal government issued rules last year that says the opposite. These rules are likely to be challenged now, and makes it very clear that other aspects of human sexuality are included within gender. Can I just be clear about that? That includes significantly sexual orientation, but even more controversial is the issue of gender identity, and that is the view that many people see their gender as other than the binary view of gender, specifically people who are transgender and identify opposite their biological sex at birth, or people who are non-binary. Have anybody heard this term before? Non-binary persons identify as neither male nor female, and that is in direct conflict with the newfound federal government's executive order that says a non-binary person would not be considered to be a legally protected status of an individual. Again, don't lose yourself on this. Colorado law makes very clear that persons are protected on the basis of their gender identity, even over the federal government's objections on this. And the executive order flies directly in the face of a Supreme Court rule from 2020 that expanded the definition of gender beyond biological sex. Specifically says gender includes more than your biology, including your sexual orientation and your gender identity. So you can imagine these executive orders are going to be subject to challenge legally because they conflict with existing law. Please.
As you're saying federal law and Colorado law, does Colorado law always trump federal law or?
Interesting.
We always follow Colorado law.
Interesting enough, well, federal law preempts state law generally, except when it's more favorable to the benefit of the employee. So we follow as businesses, both federal and Colorado law. Colorado law is very clear in protecting this particular population of persons. So nothing under Colorado law is going to change your requirement to protect people on the basis of this particular protection here. It's a great question. Let's keep on going. I will say though, why I love your question is federal law will invite people to raise more religious objections to what people view as disagreements over issues of gender. I do this every day. I'm not trying to be disrespectful, but I get a lot of people who say, can I give an example of this? And this may happen in any business where a non-binary employee, and by the way, you may never know your employee is non-binary. You may never know because most people are non-binary present typically, as you might reasonably expect them, under normative conventions. But they would certainly identify to you that they're non-binary, principally in this manner, either by a naming convention, they've altered or changed their name, often to a gender neutral name, or more commonly, they use gender neutral pronouns very commonly. So I, for example, identifying as male, use he, him, his as the pronouns associated with me discussing myself. A non-binary person more commonly uses they, them, theirs, common gender neutral pronoun. People actually raise objections to that, that's inconsistent with their religious views. If you believe that gender is exclusively male or female, someone might say that's not consistent with my view of gender, and therefore raise objections to using they, them, their to describe another person. By the way, can people hold differing views on this? Yeah, it's America. Got to get that right. But interestingly enough, under Colorado law, you have a right to be referred to by your preferred names, pronouns, and forms of address. So when you say, I say I'm non-binary, please refer to me as they, singular they, and you refuse, it raises a legal question. Are you harassing me because you refuse to recognize the fact I'm non-binary? That's going to be the issue. Someone's argument is going to be, I'm doing this for religious reasons, and that's why I ask for an exception to referring to you by they, them, theirs. These cases are starting to manifest themselves. They'll be lively during the Trump administration as people gauge what is the extent of religious protection. I'm going to also share with you, because we want to solve problems. Can you go your entire life without using a pronoun? I'm not trying to be tricky or weird and agitator, but I do want to be clear about this. Pronouns are substitute for nouns. You can be strident as much as you want about this, but no one is required to use a pronoun in this country. They are simply not. What can you simply elect to do in the alternative? Just use their name, and you can live a rich and fulfilling life without getting into any legal controversy. So there is a question of respect. And what is the measure of respect you're prepared to afford another human being? I'd like to talk about that a lot. Do we always want to be respectful, even over our differences? I would hope, even though politicians don't demonstrate this always favorably, that people get that at work. And I don't care how you see the world, but you have to be respectful of the people that you work with. That's a reasonable demand of any business, by the way. I'm not going to talk about the Department of Labor in great extent, except for a couple of things. So we're already seeing this. You probably have seen where the Trump administration is paring down the federal government already. We're starting the system of hiring freeze. They initiated today. They're actually culling workforces, seeing if they can cut money. I think a lot of people don't necessarily object to shrinking government in many respects as a cost-saving mechanism. The next one you need to know is important. If you have no knowledge in this area, it's important for every business to understand this. There is going to be a concerted effort to really hone in on a very big issue in the election, and that is immigration enforcement. How does that affect employers? In one principal way. This is a big deal. That how employers are in the immigration chain is with the requirement of the I-9. And by the way, every business has this requirement, and that is when an employee is hired under federal law, you have to verify that you are not only yourself, but you are lawfully authorized to work in the United States. Every applicant who gains employment has to complete the I-9, verifying they're authorized to work in the United States in the first 3 days of hire.
Question about the potential for raids, as to
Yeah.
put it. I know that, so when OSHA will have certain areas of focus, certain businesses, they say this is sort of our focus. I was in like the brewing industry once upon a time, and it was like, okay, heads up, that industry's on the list. Is there any precedent that the raids might work in a similar way? Like, we're gonna really focus on construction, and if you're in home goods, maybe less, concern. It seems like they couldn't just go every single business in the entire US.
Yeah, it's a great question. So I'm going to emphasize this because we're recording. This is a great question for businesses. So how does the federal government actually engineer these raids for audits? So typically, the experience has been industry specific. So the two ways that they often put their focus on these enforcement efforts is one, either industry specific. We're going to take a look at construction trades because this is an area in which people might skirt these rules to gain a vast pool of labor. So that's one way. The other way that they engineer their raids or enforcement efforts is through complaints. So if someone says, a good citizen calls up and says, man, there's a lot of so-and-sos working at such and such company, they will focus their efforts on complaints that are raised. A concern in America is there's going to be a lot of tattletaling going on because That's what people think is the appropriate thing to do. And by the way, that's your prerogative if an injustice is being manifested. But the concern is there's gonna be a lot of this type of, loose lips sink ships, problem of people sort of tattling on their neighboring business. And so that's gonna be another effort. What I want to highlight about your excellent question is this. The real concern for business is your example. Someone comes in on an OSHA complaint. There's been an injury sustained in the workplace. OSHA, the Occupational Safety and Health Administration, will show up. But the OSHA investigator says, can I also see your I-9? So cross investigations. And there is no limitation necessarily on the federal government doing something like that, where they could start to, and the concern is that they could start to do these cross investigations and review both. So just a word of advice on this great question is you want to make sure not only you have these I-9s, but you want to review them, have to have an I-9 for every employee, have to retain them for an employee that's left even within the last 3 years. But you should consider having those I-9s in a separate folder or binder. So if someone says, can I see your I-9s? At least you can make them more available readily. So no one's looking through your underwear drawer at work, looking for mayhem that they may focus their attention on.
They're
So
required to be on site if you have like a third party HR person.
your I-9s have to be readily available for inspection. So if they're reposited in a third party, they have to be subject to ready examination by anyone with authorization to search.
What about a digital electronic scanning version? Would that be acceptable?
They have been, and certainly were during the COVID period, that you can do electronic I-9 recording and retention. And so as long as they're properly verified, and you have the employee's signature to attest to their, you could have an electronic form of an I-9 record, subject to review. Yeah, these are great questions. Let's keep this love alive. Private sector employers, just gonna hit this one quickly because it's in the slide deck. And I love these questions. They make me go faster through the slides. So I'll skip a bunch of them later on. That goes to this one. We talk about this every time we get together. Everyone knows that private sector and public sector employers are subject to the Fair Labor Standards Act. This is America's compensation requirements and law. So the Fair Labor Standards Act says you're either exempt or non-exempt. Most people are aware, and should you have employees, this. Non-exempt employees have to be paid at least minimum wage. And they're entitled to the receipt of overtime once they generally work over more than 40 hours in a work week that you have set for them. Exempt employees, which is obviously many of you, you're typically leaders in your own organization, they only have to be paid a salary. And the salary has to be sufficiently high to avoid the payment of overtime. The current salary threshold is $35,568. It was to have gone up to $58,000 this year in an extraordinary Biden administration effort to raise this threshold from more than $23,000. It's a 70% increase in the salary threshold. And federal court struck down this effort this year. You might remember this because this was a staggered issue. You probably heard about it. It went to $43,000 in July. Many employers changed their compensation structure to make sure that they're exempt employees. To avoid them getting paid overtime, they raised their compensation level to $43,000. Many people have sustained that, but now the current state of the law is you got to be paid at least $35,568 under federal law. Hold on though, private sector employers. Colorado has its own rule about this that I want to show you, which is much more like this than this. And so we'll get to that. Yeah, please.
Just a quick question about the independent contractor classification was up there.
Yeah.
Doesn't Colorado have its own rule on independent contractor classification?
Yeah, Colorado has a variety of independent contractor rules. It's important that people know that as a matter of law. So we have a separate independent contractor test under our state tax code. We have an independent test under our workers' compensation statute, which is significantly important because people who are hurt on the job, independent contractors don't get workers' compensation, employees do. And we have our own independent contractor test under our unemployment statute. So we have a variety of tests. They all focus on employer control of the output of labor, which is the common test. The more you're independent, you're an independent contractor, the more employer controls the output of labor, requires you to use certain tools, be on the premises, limits your hours, controls the output of your labor, restricts your ability to work with others, which is the principle of control. You're more likely to be an employee. The more independent you truly are, you're likely to be a contractor. Interestingly enough, you made this class go faster as well with your good question, because immediately, I believe this may have happened already today. The Trump administration has eradicated some of the orders of the Biden administration, including a very employee-friendly independent contractor test. Now is likely to revert to a very employer-friendly independent contractor test that the Trump administration instituted more than 4 years ago, or 4 years ago, actually, at the end of their administration. So here's the bottom line. Under federal law, a lot easier for businesses to have independent contractors to escape their responsibilities legally to manage your employees. Colorado still has its own rules. That's why I like your question a ton, but it's going to be easier to have independent contractors. That's really going to support the gig economy, in which a lot of independent contractors typically live and work in that space. Again, these are good questions. Keep this love alive. It's fantastic. Talking about National Labor Relations Act, I just want to mention briefly, everything that the Biden administration did with regard to organized labor and the rights of employees has been wiped away essentially, or will be wiped away by the Trump administration, back to a much more employer-friendly view of the world. That shouldn't surprise you. That also happened way back in 2008, 2016. This is when President Obama took office. He changed the Bush administration. This is the first Trump administration, changed the Obama administration. This was the Biden administration, changed the Trump administration. So it's basically the tennis match of labor relations in this country has swung back to a much more employer-friendly view of the world. That's really important if you have a handbook, because the Biden administration looked at handbook provisions as potentially chilling employees' ability to complain about matters of importance in the organization. Now the Trump administration is going to have a much more hands-off view of employer communications, and handbooks are not contracts that bind employees into more protections. Let's keep on going. Workplace safety. I already saw that the Trump administration eliminated a COVID era protection under OSHA yesterday. I expect they're going to attack the heat safety rule. If you're unfamiliar, I just had a debate about this. You probably know, if you haven't heard, there is a booming debate about climate change in this country, and whether people are willing to accept it or not. It's actually fascinating to me that people literally, and you're entitled to have differing views on this, but can I just say one thing, especially if you live in Colorado? Does it seem like it's getting hotter? Okay, I'm not trying to be controversial in any way, but I am from here. And I have to tell you, I'd never had a 100-degree day in the entire 50+ years I've lived in Colorado until the recent past. So it seems like it's getting hotter and hotter at 5,000 feet than it ever has been. You can disagree. And of course, the real issue is whether you think what causes it. But it doesn't really matter, because the Biden administration proposed a very important heat safety rule to protect people from heat-related injuries. That rule is likely to go the route of other rules proposed by the Biden administration. And so I would expect there will be nothing here on this unless there is just something that changes the Trump administration's mind about it.
General section, all the back road changes. So is it, did people come back and say like in 2024, the law was this, and so we're gonna hold it accountable with the whatever you, and it's not even about a particular one, but can you still be trying to prosecute maybe for years or having late for stuff?
That's a great question is, what's the retroactive application of these rules? There really isn't. And so you can't say that there's a retroactive application like back in 2023, you were subject to this rule and therefore you violated this rule. It's going to be hard to do that under these rules. I mean, obviously if it's still within statute of limitations, but if the rule changes, the government isn't going to necessarily enforce those violations back in 2023 during the Biden administration, because the current administration is enforcing their own rules only. And that's the real message about this back and forth is, the bottom line here is, employers, all of you, there's a substantially more deregulated environment federally for all of you. That's not viewed unfavorably by many employers, I might add. Colorado still has a substantially more regulated environment. So it's not like you're walking through the, dust and like, oh, I'm clear. It's still, employers are heavily regulated, but less so in the Trump administration. Which goes to artificial intelligence. I'm just gonna mention this. If you use artificial intelligence as part of your work experience, and some employers do, the Biden administration, passed or wrote, an executive order on this issue. I saw that the Trump administration, rejected it yesterday. So we have no idea what the Trump administration's view is about the use of AI. Again, you heard my comments. This is a deregulated environment that we're walking into. So I assume that there may be no guidance with regard to use of AI, artificial intelligence in the workplace. But Colorado's got a rule about it, so we got to talk about that. That's why it's fun to come to this stuff, because you live in Colorado. And so let's go through it fairly quickly. You good for me to go fast? So just make note of anything, and please, the questions are great, and so let's keep this same dynamic alive. So I'm gonna just dig into Colorado expectations. Yeah, please.
I just didn't know if we were gonna touch on the comp order or the standards and duties test.
Yeah, we're gonna talk a little bit about that. So if you're unfamiliar, and I wasn't gonna actually give the exact details on the comps order. So if people are familiar, this is a big deal, and thank you for teeing this up. So first, Colorado has a pay calculation order. So that's where this comes from. And then I'll talk ideally about the comps order in a little bit. And every employer should be well aware of our comps order. So let me talk about both. So the first thing is our minimum wage and minimum salary. These are set every year by the state of Colorado. They typically are tied to the consumer price index and how much it goes up or goes down. So this governs every employer, every private sector employer. I don't know if there's any public sector employers in this room besides our city of Arvada, but are you a public sector employer? Oh, good. So you're not necessarily subject, if you, this is only non-governmental employers, but you have to pay at least $14.81 or minimum wage went up. If you have a Denver business, Denver has its higher minimum wage. I saw Boulder just initiated its own higher minimum wage. And I believe Edgewater might have, there's a third jurisdiction that has a higher minimum wage. Colorado allows cities to set their own minimum wage as a matter of state constitutional amendment. But those three specifically have higher minimum wages for workers in those jurisdictions. But statewide, it's $14.81 for an employee. This is the thing I mentioned earlier. We also have a sliding scale in this pay calculation order to maintain exempt status. Again, only private sector workplaces. This is most of you. In order to be an exempt employee, not receive overtime, you have to be paid at least $56,485 a year, up from last year's $55,000 per year to be an exempt employee. You get the big difference there. State, federal law is $35,558. Colorado law, and again, going to your great point, the more generous one applies for the benefit of the employee. So $56,000 to be an exempt employer. This for a small business is going to be devastating, and that's why many smaller businesses elect to keep their employees out of the exempt ranks and simply avoid working their employees more than 40 hours a week to avoid the payment of overtime.
Does marital status and how you file taxes have any bearing on these numbers at all?
No.
No.
That's a great question. So that's not going to necessarily change this amount. We have differing wage rates though for different classes of employees. For example, for disabled workers, tipped employees, there are different pay calculations for different classes of workers, but not necessarily based on their marital status. In fact, Colorado law will talk about it, equal pay for equal work. You have to pay men and women the same. And it's because of gender identity that we take the same. Other rules about this. I don't know if I put any changes to the comps order in this, but I did want to hit the excellent question about this. So Colorado amends what's its comps order. This is how Colorado governs work rules and work requirements akin to the Fair Labor Standards Act. And they do have their own duties test. Well, I love your question. They do have their own duties test for determining who is an exempt employee. To be an exempt employee, you have to be paid a salary of at least this amount. And you do have to have Colorado's required duties test set to be met, which could be more restrictive than federal law in this regard. So Colorado's got a fairly narrow view of what it means to be an exempt employee, and you have to check that. Every business, I don't care if you have an HR function or not, you should have a copy of the comps order. It's downloadable from the Colorado Department of Labor and Employment's website. If you simply go to notices or employer tab on that, everyone should have that electronic version of it at least. Question?
How do the Colorado laws apply to a remote employee in their state? Right, they're based in Colorado.
Yeah, it's a great question. So typically, and this is always a debated issue, it almost depends on the law that potentially you're being subjected to. Colorado's basic rule on this is, even though the employee may be remote, if they report to a Colorado headquarters or a Colorado business, they may be subject to Colorado's rules with regard to their employment rights, which is interesting. Now, a couple of exceptions on that. For example, on giving notice of job openings under our equal pay for equal work law, which demands pay transparency. If jobs are exclusively remote, you may not have a requirement to post or give notice of those because you're not hiring employees to work in the state of Colorado. So it always depends on the issue that the government is trying to enforce. A good example would be taxes. It is conceivable that Colorado could want taxes and the compensation of a remote worker because they're headquartered here in Colorado, but also the state in which the employee lives, California really is into this, could also be looking for compensation and taxes on it, which is derived in the state of California. So the employee who's working remotely could have considerable tax consequences depending on how tax friendly. Wyoming, favorable. California, not so much. And so that could be an issue for the employee, not necessarily us, except for if we somehow have failed to take withholdings inappropriately under California law.
Well, how about like the exempt, which, say I have an employee and they're reading this for them.
Yeah, their rule is way more favorable. The issue there is, I have to tell you, this is one of those things, I want to talk to a lawyer about this, because interesting enough, do they work exclusively in Wyoming?
Yeah, like they live around, they work from home.
Is their supervisor, where's their supervisor located?
Yeah.
Do they take direction from Wyoming or from Colorado?
From Colorado. So like the whole company in Colorado, but they have one employee that's in Wyoming, works from home.
Yeah, I have to tell you, I have a considerable risk concern about this. My view on this would be though, this employee actually is situated in Wyoming and therefore is subject to Wyoming's rules with regard to this. So I would take the employer approach and put the burden on the state of Colorado to determine this employee is somehow working in Colorado, because it sounds like they're not.
We do have to pay them to Wyoming.
You do or don't?
No, do.
Yeah, good.
Yeah.
Oh, good. So you
Yeah,
treat them as a
they-
Wyoming employee. Yeah, that to me is just having multi jurisdictions of work. You actually have assigned employees into other states. And so it's not like someone is a Colorado employee that's simply working over there. It's we have an employee in Wyoming who's working under Wyoming law. That's appropriate for me. And I assume they do business remotely here though, correct?
This scenarios.
Yeah.
Obviously, they have clients that have employee.
I could live in your world, but I'm cautious about how this employee is classified, is that it's okay to determine them as a Wyoming employee for purposes of taxes, as long as you are making withholdings, they understand they're a Wyoming, subject to Wyoming taxes, that's reasonable for me. Of course, they are not gonna want to check, that's my big issue. And the state of Colorado is gonna be unconcerned, they're unlikely to know about it. Because you're treating them as a Wyoming employee. Yeah, that's all right for them so far. Please.
Real quick, so what's this highly compensated employee?
Yeah, this is a great question for people. Thank you. And I put it in there and I expect questions on things that I don't necessarily touch. So under Colorado law, and by the way, this is the same as federal law. It's just a lower threshold. Under federal and Colorado law, if you're highly compensated, you're presumed to be exempt and not entitled to overtime, as long as you meet the duties test that was alluded to earlier, but you're presumptively exempt because the presumption is if you make this amount of money, you likely have important responsibilities that would make you an exempt employee. So we sort of take a non-enforcement position on people who are highly compensated and assume they're not entitled to overtime. But in Colorado, to get that assumption, you gotta hit this amount. In order to be presumed to be exempt.
So we have employees that are salaried. And they're supposed to work 40 hours a week. Sometimes they do, sometimes they don't. We have no way of governing or monitoring, I guess that's more the word, monitoring how many actual hours they are working. So when your employees come up to you and they're telling you that they're working 14 hours a day. Do they get overtime?
I hope they're exempt.
They are.
Okay, that's
Right now,
important.
so they're getting more than the 56, but they're not getting 120.
Yeah, it's okay. As long as they're getting 56 in Colorado, you're good to go. As long as they're exempt. Goes to the
Okay.
great point. Gotta have this duties test, because any employee under any work circumstance can challenge whether they're exempt or not. And when someone says they work 14 hours a day, could you expect they might challenge their work circumstance? Because what do they want?
That's what I'm afraid of.
OT. So here's what you do. You always should be everybody should be conducting a periodic audit to ensure that whom you claim is exempt is truly exempt. Because get this, I'm gonna try to be plain about this. A lot of employers think they can cut corners on this and try to have an entire labor force of entirely exempt employees to pay no one overtime. Guess what the state government's view on that is? It's impossible. Who's the worker bee here? Who takes out the garbage? Who answers the phone? Who does all the, gets all the snacks for people when they show up? Those aren't exempt employees. Those are non-exempt employees. Who's making the donuts or the beer? Those people should be getting overtime if they're working 14-hour days. So I'm talking about people who are paid more than $56,000. They're either exempt executives, meaning supervisors of 2 or more people, administrators, meaning independent decision makers. They make decisions for your business that are of some importance. And then finally, they're professionals, your accountant, your lawyer, your nurse, your doctor, you get that, school teachers. Those people are exempt as a matter of law. And so those people are okay. So you have to know the people working 14-hour days are exempt. Sadly, the other side of this is that for exempt employees, is anybody here exempt? You already know this, especially if you run a business. Could I literally work you to death? That is the dirty little secret of being exempt in America. Could more than 8 hours a day be demanded of employees? Yeah,
So I use the theory that this is my minimum, that I have to pay you for salary, an employee exempt. And if I pay you 90,000, that sort of helps compensate for all that overtime that you're expecting.
you have to make this clear to employees because employees who are still non-exempt, regardless of what you pay them, can still lay claim to overtime. There is a way, this concept, paying a set salary for all hours worked, including for someone who says they're non-exempt, still requires you to pay overtime if they're truly non-exempt, but you only have to pay them under at least the Federal Fair Labor Standards Act. Colorado also has this rule, only additional halftime for their overtime hours. That is for a salaried, non-exempt employee. You only have to pay additional halftime, but you gotta pay them extra money if they're non-exempt. Be cautious about that. Having salary requirements to assume all overtime could be a suggestion. You really think they are non-exempt, which reinforces our concern. But they're gonna say, you treat me like I'm non-exempt. I think I am non-exempt. And you know what I want? I want OT in some fashion for this, which by the way is the American way. And it's important that people get paid for the work that they do for you. I love this question. Other questions about this? All right, let's keep on going. This is all good stuff. Talk about a couple things that are sort of important. You got a little bit of a window here to talk about this. I hope this is none of you, but if you in any way, have you ever heard of a law called HIPAA, which requires us to protect protected health and protected information of our employees? Colorado has now jumped into this a bit. They amended our Colorado Privacy Act to include employers. And here's just the message. I just want you to know, I doubt many of you are doing this, but if you in any way are retaining biometric data, you have to safeguard it. What do I mean by biometric data? That is fingerprints, facial recognition. I can't get on my bank on my phone without my face, which isn't that great, to get on my bank. All that data, facial recognition, voice recognition, has to be maintained in confidence. You have to safeguard it. You have to notify employees that you're safeguarding it. And you have to monitor whether there's any intrusions or people trying to take that important information. Could identity thieves use that for all types of nefarious purposes? So just know that if you have biometric data, you have to safeguard it.
If there's a laptop that I'm providing to my employee and they choose to use the like biometric logins, but I don't know how to access that, does that fall within it?
It's a great question. Is it an employer-given laptop?
Yes.
It's conceivable to me that that is some data you would have to safeguard. So hopefully the employee has their laptop encrypted. Hopefully the employee's laptop is safeguarded as a matter of use. And you should require that they have to safeguard and encrypt the data that they use to gain access to their computer. That's gonna be something you're gonna want to maintain because gosh darn it, if someone hacks that computer and gets access to that data, that would be a potential claim against you for not managing that fairly effectively. And again, you know, we want to make sure that employees are using our equipment reasonably, and you should certainly have a rule about that, which is what this law tells us. How do employees safeguard their computers? And there are a lot of security protocols that employers are required to attend to meet this requirement. Next one, I'm not going to talk about this. I will say, this law has been expanded last year to include if you're retaining biological or neural data on your employees, brain function, brain scan data, that's also going to be shoehorned into this requirement to safeguard. So I don't know if you're like making employees, you know, swab their mouth or pull their DNA or anything like that, but you got to safeguard all that stuff just so you're aware. Let's keep on going. I'm gonna do this quickly because a lot of these are just one-offs. They're things that you shouldn't necessarily know, but I'll take any questions on them. So this one's kind of a big deal. I'm not gonna talk in great detail because it's changed. These are all just changes to Colorado's law in the last year. So let me just highlight them quickly. No big comment. So everyone in business should know, Colorado is one of the few states which in the instances of workplace violence, domestic violence, not only can a person who is the victim of domestic violence get a restraining order or a protective order, but in Colorado, businesses can get restraining orders to keep domestic aggressors at bay. I don't know if you're aware of that or knew that, but we as a business, so the Arvada Chamber could go and get a restraining order to keep an aggressor from entering this building or get within 500 yards of it. And of course, you know why? Because when someone's bent on harm, who is else potentially susceptible to injury?
Everyone else.
Anyone standing in proximity to that employee who has a domestic stalker or aggressor on their trail. And so that's why the rule exists, to safeguard the entire workplace from this issue. I only mention this because Colorado has lowered the bar a bit to getting these restraining orders. Workplace violence is important. Just know there's a tool out there that allows you, if you have this fight of your employee's life, that you want to talk to a lawyer about potentially you getting a restraining order. Now, of course, could the employee also go get a restraining order with some assistance on your part? Yeah, there's a means for doing that, reasonably low cost for a person to keep a domestic aggressor at bay. But you can keep people who are potential suspects of domestic violence away from your premises. Yeah, please.
Is an employer obligated to do that?
Great question. This law doesn't necessarily set a standard of care in this regard, meaning that you must do so. The open question would be if in the event of an employee was actually harmed by a domestic aggressor, did you not exercise a reasonable standard of care? Why didn't you get a restraining order? That I've never seen that case litigated in Colorado where someone would claim an employer was neglectful for failing to utilize this process, because it's not required that you utilize this process. And of course, most importantly, we may not be able to gauge the threat. I love your question though, because you can imagine where an employee says, look, I'm scared. Or even worse, the employer has independent knowledge. Can I give an example of this? I had a case a number of years ago, bank here, actually up here in North Metro area, where employee was parking his Colorado, just roll with me, his pickup truck, literally in the parking lot of this bank at the front window, like this, and would stare through the front window at his former partner, super creepy, all day long, sit in this car. And everybody in the bank's like, look, And it was, I can't, as you probably know, just wigged out everybody. That would be a case in which, and by the way, they did get a restraining order, that's why I tell their story. It'd be weird though, if, God forbid, if they knew of this threat and they didn't get the restraining order, but more importantly, didn't encourage the employee to get the restraining order. Would there be some liability if the employee was harmed? Luckily, the employee wasn't harmed. Luckily, they got the restraining order. Luckily, the person, as some do, went away and certainly went away of their existence. But I could see where there'd be a concern about liability in this regard. Please.
So, if, let's say a manager learned about a potential threat to an employee and the management team felt unsafe, but the employee didn't want to do anything, would there be any kind of violation on the employee's rights if the employer decided to have a restraining order against this person?
Against the employee or the domestic
Against
aggressor?
the aggressor.
Yeah, probably not. I have to tell, I love your question about how to manage domestic violence in the workplace. So what I thought you were gonna ask, it sounds terrible, please don't hold this against me. What happens a lot of times in my circumstance where we're all afraid of this menace, the employee is not as concerned because, please don't take this negatively, sometimes this is common behavior for people who are being abused to turn a blind eye and literally a deaf ear to abusers because it's been normalized, socialized, or they're forgiving of these transgressions. But you, business owner, are like, nope, this person could show up and hurt us all. So what happens there is we have the conversation about protecting the employee. Colorado has a law that says we have to give employees time off to get protection if they're victims of domestic violence. So it begs for a hard conversation about what should we do about this. Normally, we encourage the employee to take the time and resources to get a restraining order. That's something that's commonly done by employers. Going to your point, well, I don't think we want to do this because does it create an additional burden for us to protect the employee if we do it? We'd rather the employee protect themselves. And more importantly, they can get a restraining order for what? More than work. I can keep them out of my neighborhood. I can keep them out of my job. And so I kind of want them to get it anyway, because I want them to protect themselves at all times, not just work times. I'll be clear, that's why most employers don't do this, is I think there's a bigger problem here than work. But what happens, why I love your question is, sadly, if we are reasonably apprehensive about our safety and this employee can't abate or minimize this threat, I have had the experience where we move the employee along in order to reduce the threat to our particular workplace. There is a potential threat that they would sue over this, but you can imagine what's our reason for terminating their employment? Safety of everyone. And so that has happened. That's a hard conversation. I will tell you, every time we've done that, we've given the employee a very soft landing in this regard. Look, everyone's apprehensive. We can't minimize this threat. Here's what we're going to pay you and give you to move on. Ideally, you can not let anyone know you're moving on, and that way you can potentially evade the aggressor. Because here's the concern with the employee. Here's the thing. Guess where they know you're at? Here. And that's why we have to talk about this. The more you're here, the more raises the specter of safety for all of us. So those are hard conversations we've had as employers with employees. But I don't think you have necessarily liability. I think you just have to really ruining somebody's life a bit because they may great employee, but every employee is scared to come to work every day. And that's a hard conversation. Thank you for teeing that one up. That's a difficult employer responsibility. All right, let's do a couple other quick ones here. I just want you to know, if you have delivery network drivers, these are independent contractors that you use as route drivers, deliver sales or goods. Then there is a Colorado law that requires you to potentially give more information about them. And you have to have more transparency about their use of these drivers. So if you use delivery drivers, we have a rule around that. Please look into it. Next one is non-competition agreements. Not going to talk about this. Everyone knows, if you've ever been in one of these classes before, everyone has a business in Colorado knows. Non-compete agreements, non-competition agreements are viewed very favorably under Colorado law. I think most business owners kind of get that word on the street is we want to keep employees from competing against us. Very hard to do in Colorado. Now we only have really a couple of authorized non-competes. The first one is in the the protection of trade secrets. If you have trade secrets in your business and you want to protect them, you can bind highly compensated employees. That number comes back to haunt us. You can bind highly compensated employees in the protection of trade secrets. So that's one that's authorized. The second one is if you are selling your business, you can be bound to a non-compete agreement. Famously, Gart Brothers, if you're from Colorado, sold their sporting good business. They were bound by a 5-year non-compete agreement to not start a competing sporting good business. But I'll tell you what, the day after 5 years ended when they started Sports Authority, right? Which is another business after their non-compete expired. That's to give the new business owner the chance to get into the marketplace without, any competition by someone who had the marketplace before them. Last one is training reimbursement agreements. I just want to mention this. These are commonly used. If you spend money to train your employees to meet certain jobs or duties, you can bind them to so-called training reimbursement agreements. These are in many effects non-compete agreements. Because what's the rule? If you leave us within, you have to have a 2-year threshold on this. If you leave us within 2 years, you know what you owe us? All the cost of training you. The rule there is you have to have a sliding scale. Every month or every year the employee is there, you have to reduce the amount that they owe you. In essence, they paid back the training reimbursement. Colorado allows you to have these reimbursement agreements, but they have to follow Colorado law or you're susceptible to huge damages for violating this.
Does it have to be like third-party training or just the fact that you work there and someone else who has worked there and they taught you how to do something?
If you can, great question is like, what's the extent of the training? As long as it's calculable as a cost, I mean, you can't make it up. So, typically this is where people go through a training experience that has a dollar cost. You went to this class, you took these classes. It's conceivable though, internal training could have a cost. Is we expended this amount of money for this employee to train you or mentor you. So as long as it's a calculable cost, why I love your question is, you've got to have the burden of demonstrating this reasonable cost of training. So if you start to go, you owe me $1 million for working here, it's gonna not pass muster. I love that question. It's on you to tell me what is actually the cost of this training, and that's what the employee is paying you back by their continued employment. Yeah, you're rocking these questions. Yeah, please.
Related to that, do we as the employer need to have the employee sign anything that says, I understand I'm going to training and if I depart this company within a 2-year period, I'm responsible for paying you back?
Absolutely. It's another good question. Please remember under Colorado law, the ability to deduct an employee's wages, including final wages, requires a written agreement which attests to that. You should know in Colorado, you can't make employees pay for breakage, damage, loss, injury, theft, unless you have a written agreement to that effect. So not only do I recommend you sign a formalized training reimbursement agreement, I happen to be a fan of employees signing a companion to your good point about the reasonable cost. I require employees to sign a promissory note that, hey, you owe us $4,000. It will be reduced over the course of the 2 years you work here incrementally as follows. But if you leave, you will owe us the remaining balance of this promissory note. Is that easier to enforce in a court? A lot easier. Go into small claims court. Here's what they owe me on their promissory note. And you're going to get a judgment for this amount of money that you could more reasonably collect from the employee. You got to have an agreement to effectively do that. That's a good question. You can't just say, you owe me this, I'm going to take it out of your final paycheck. That's not going to work under Colorado law. Yeah, these are good questions. I'll do this. I wish, Cammy, thank you. It's fun for me. I want to leave time for you, but I want to make sure. Let me do a few more and we'll get to the end of this. I'm not going to go to a lot of the issues. I want to talk about a few things that are really important. Just want to mention quickly, for people, this is all businesses. That's why I'm using this. So in Colorado, we have 2 changes to our civil rights law last year. None of these are going to be earth shattering, but they're important for understanding. Colorado has the Crown Act. This is a law we've talked about that says employees, and by the way, school children in schools have a right to wear racially distinct hairstyles. This is subject to repair past discrimination based on race, where literally people would apply for jobs and be rejected because their professional appearance was challenged because they would wear, I'll just tell you, afros, dreadlocks, bantu knots, cornrows, and employers would say, nope, that's not the professional standard that we're looking for here. Applicant, primarily Black, would be rejected. backhanded form of rejecting people on the basis of their race. So Colorado repaired that. 26 states have this protection as well. It was effort in federal law, did not move forward. So Colorado has this protection. You can't hold the fact that people wear racial distinct hairstyles against them. The only change here is they added hair length to hair texture, hair type, and hair styles. You know why that's cool for me? My hair length, but you know what's cool is that we live in Colorado. And you probably already know this, since a lot of you are from Colorado or lived here extensive time period, but think of all the native and tribal identities and affiliations in Colorado. Could hair length be part of your tribal or native identity? And would that be something that someone would desire to wear in a workplace? The only question I really get about it is, in the trades, you talked about, making beer, things like that. You are allowed to have reasonable restrictions on appearance for safety or hygiene. So if this person's cornrows or dreadlocks are unsanitary, or could potentially be a safety risk because they operate power-driven equipment or machinery, you can still have reasonable safety rules about hair length, hairstyle, in order to ensure the safety of employees. Just know that. I'm not trying to be tricky or weird there, but a lot of people have hard jobs.
You can have the long hair, but you have to tie it back.
Exactly. You have to make sure your hair is worn so it doesn't catch in power equipment, and you can make a lot of accommodations to that effect. Wear it in a hairnet, whatever it might be. Let's keep on going. Organ donors, that's why I love talking about this stuff. Okay, who would be against someone who donated an organ? I mean, that is next level insane mean. So like, you donated a kidney, but you missed some work. It's like, what? So I just want to remind people, Colorado ramped up to make it very clear that if an employee has donated an organ, in the period 30 days before and 90 days after, you can't potentially take any adverse action against an employee during the period of organ donation. By the way, I've never heard of this happening. I think most people who donate organs are heroes in our society. Literally, they're revered. And so, this is just a reminder, is even though you're having a bad day at work, someone else may have donated a kidney. And they should get your best effort, just so you're aware. So just know that organ donors are protected in Colorado. I like that rule. I think it's intuitive. I just want to remind people, it encourages people to do what? Donate organs so no one can jerk them around. So keep in mind. AI, this executive order was just eliminated yesterday by the Biden administration. I do want to mention a couple things about this. This is important. That's why Cammie, really, I appreciate her giving me this forum. So this is going to potentially affect people who use AI. So Colorado became one of the first states to regulate artificial intelligence. That was passed in this last session. 2 rules here, because the most common thing I get is the answer to this question is, do any of you use AI tools in employment? And it's not very many. And so I just want you to know, first thing you need to know if you use AI, by the way, it's burgeoning. More and more employers are using AI tools for recruiting, for hiring, you get the idea. If you use those tools, you have to determine whether they are so-called high-risk AI systems. That's going to be defined under the statute. So you may not be regulated here unless you're using high-risk AI systems. So first know that, make a determination whether you are. Second thing is you've got a year to potentially consider what to do if you use these systems. I'll share with you, I think there will be regulatory guidance by the state of Colorado of how to initiate this protection, but this is a big deal. You have to give employees, if you use these AI systems, an opportunity to address any misinformation that the computer system has used about them or others. For example, AI thinks they have a criminal arrest. They don't have a criminal arrest, but you use it against them in your recruiting tool. So you have to give people an opportunity to correct misuse of an AI system, and you have to give a ton of notification issues. The good news for a lot of people here is this: if you're small. So if you're a smaller employer, you're going to be under the radar scope of this potential protection. So it's good to be small in terms of this particular sweeping requirement to address AI in the workplace.
Can you give an example of what that would be? Job screening system?
Oh, wow. I just had a friend. Yeah, I had a friend, I don't know the name of the system, who actually went through an AI tool to gain employment. So interestingly enough, Their resume was vetted by an AI tool. There was an open period in which people who were considered actually had to appear in front of a computer monitor. No human being was involved. And they were prompted by the computer. This is, visual recognition of them. They were prompted by the computer a number of set of inquiries, and they had to respond within 2 minutes to these inquiries. And then they didn't hear another thing until they were either rejected or accepted from further interviews. But it was entirely non-human interaction. It was interaction with the computer system with an AI generated tool that considered the answers to their questions and whether they met the required prompts for gaining employment. These tools are becoming more and more common actually in the workplace, and I see a future that they will become even more common. Good questions. All right, let's do a few more. I don't want to take too much of our time to talk about history. You all know a year ago, we had the Power Act. I don't know if anybody saw this in last year's program, if you were here. So the Power Act is a new Colorado law. I just want to mention this briefly, just to hit this, a couple of quick hitters about things that you need to know. So Power Act requires us to relook at our policy guidance. Colorado now has eliminated in the requirement to prove workplace harassment any standard that misconduct has to be severe or pervasive. What madness is this? So we lowered the bar for harassment claims in Colorado. So you should be aware, and by the way, all businesses are subject to Colorado law when it comes to workplace harassment. So it doesn't matter what your size is, as long as you have at least one employee. So now it's easier to prove harassment. What has been the effectiveness in the last year? I'm just going to be honest with you. One, supervisors and lead or business owners have to be attentive to complaints of harassment. You can't say, if you don't like it here, you can just leave. Nope, that's a problem. The more important issue is the high standard to which employees are being held in the wake of this. So in my world, there's not been a lot of lawsuits filed under this change. You know why? The reality, I'm not encouraging this. The reality is, if you're accused of workplace harassment and we don't want to be in a lawsuit, guess what the conversation goes like? We need a divorce. Your behavior is drawing considerable scrutiny. It's impeded other people's ability to work with you. And therefore, it's time for us to part ways. And that's been the experience I've encountered significantly in the last year. I hate to see employees be fired because I think there's a lot of room for forgiveness for people's transgressions. I think a lot of people who are unaware their behavior is landing badly on others can conform to expectations. I like to think that to keep a job, most of us would do that. But when people simply offend their coworkers too frequently, is it easier to simply jettison them rather than to experience a lawsuit? Defending somebody, we don't really want to defend that much. And that's the issue that comes up a lot. Please know that. The other one, you mentioned marital status. Marital status is protected under Colorado law. So please be mindful of that. So I loved your comment to that effect. Is marital status is now a newfound protection in the state of Colorado. So people ask me, how is that defined? Sadly, you'll see in a later slide, they didn't define it. So I'm using the old fashioned definition of marital status. You're either currently single, meaning unmarried. You're either currently married, you're in a lawful marriage. You're either divorced or once married and now your marriage has been severed or dissolved, or you're widowed. You were once married and during the marriage, your marital partner died. Those are what I would consider to be protected marital status. Can't hold that against people. People always ask me, what does that mean? Okay, I'll give you an example. So you're my only single employee in our department, and I tell you, look, we got a heavy workload this weekend. I need your friend. Why me? Because you don't have anything going on. Why not Chuck? Chuck and his wife Sarah are in a square dancing competition in Buffalo. And I can't take him out of that, can I? I know square dance, just so you know, I like saying it, but it's funny. My wife doesn't square dance either. I don't think she even wants me to, but you get the idea. Would that be discrimination to pluck a single employee for differential treatment because they thought they were more available than a married employee? So you can't do that. Now illegal under Colorado law. That stuff does happen. It shouldn't happen, so please be mindful of that. All right, let's do a couple more, and then I know that Candy has a couple comments too. So we talked about this. Last thing about Colorado law, and then I'll move on to some closing comments because the rest of this is not as important. But because I want you to see some slides, and I want to comment for the future. But I want Candy to step up and give some comments about future events. You all know this covers all of you. Colorado has notice requirements for job openings in Colorado. This law changed last year, and it's important you understand this. Now they eliminated, you had to give postings for so-called new hires and promotional opportunities. And this promotional opportunities language was simply too confusing. What's a promotion? What's not? So I think in a sense of coherence, before we end, they did want you to know that now new hires and promotional opportunities, all job opportunities. And the code for you is vacancies, is what the statute says. So just know in Colorado, you have to give reasonable notice to your workforce of all vacancies that you fill. And so you have to give notice of those vacancies. And then here's the new one. After you fill a vacancy within 30 days, you have to give reasonable notice to the people that worked regularly with this position who got the job. That's the new notification requirement for Colorado law. So we give notice of openings, organization-wide, typically by email. You can do it by internal written posting as well, if you're small enough. But we now have to give a 30-day notice of who got the job. I'll show you this. It's important you see it. It's right here. This is in the state's rules. Remember I told you that Colorado Department of Labor and Employment, they have a number of info notices. This is what it looks like. Ally C has been promoted to analyst 4 from analyst 3. Any employee interested in similar opportunities in the future should just contact HR. So you got to say who got the job.
To move somebody from part-time to full-time, does that fall under this?
Is it a new full-time job?
Yes, so yeah.
Yeah, it's gonna be an interesting question, I have to tell you, because here's the thing that's good news about this, is that career progression and career development positions don't have to be notified. So if someone would naturally go from part-time to full-time after 6 months, that probably does not beg for a notice requirement. If it's a new job that you've created, then you have to give notification of that. I get this question a lot, is if it's just a basic career progression, someone goes from, analyst A to analyst B after 6 months. That's just in the progress of their employment, no requirement to notify anybody of anything there, which I kind of like that rule. It's just they would have gone there anyway, and everyone should know that because they knew it when they started work. Does that make sense? Last thing I want to mention is this. Hold on. That's public employee stuff. Is not this, but this. So I told you the Trump administration is going to change a little bit of work. 2 things before I end. And again, just want to mention, we have these pregnancy accommodation rules I alluded to at the beginning. I just want to end on this. I would expect the Trump administration is going to jump into this. So please, I wanted to give them to you. These are the federal guidelines of how you accommodate pregnant employees. The other thing I want to mention is this, harassment guidelines. The federal government came out with harassment guidelines last year. And once again, this is for next year's session. I think the Trump administration is going to peel back some of these harassment guidelines. I wanted to give you the guidelines so you would have them, but please, when you leave today, know these guidelines may be subject to not only elimination, but substantial amendment. I already stole my thunder on this. Issues of gender identity are clearly protected under federal law in the Biden administration. Issues of pregnancy and pregnancy accommodation clearly protected by law in the Biden administration. Both were met with religious objections by Commissioner Andrea Lucas. So I think these rules might change this next year. Cami, I don't want to steal any of your thunder. I know I'm at the end of my time. I'll stick around if people have questions, but I want to make sure Cami this is the formal end of our program. Don't know what you want to share, but I want to make sure you get a chance to share.
Well, I first want to share how awesome you are and
thank
have everyone thank you. Great job, Chuck.
Thank you.
Amazing. We appreciate how approachable you make these difficult conversations. I mentioned at the beginning that on your chairs, there are these little Join Our Network cards. I would highly encourage all of you to fill these out. Based on who's here today, I would encourage you to look at the advocacy one. We do send out alerts of what's happening in this legislative session. Kind of a little known fact, we actually have a paid lobbyist through the Arvada Chamber, and we are advocating on behalf of our small business community live at the Capitol. So we are sending out updates, we are tracking bills. So if you're interested in staying aware of those bills, we would love to be able to send you out those alerts. The other one I would welcome you to join that you might be interested in is our entrepreneurship list. Allie, who's in the back, runs this business resource center. We do have countless education and training programs that come out of this building. And so we'd love to keep you informed about what those are, when they are, so you can join when it makes sense for you to be part of those. If those other areas are of interest to you, we'd welcome you to join as well. And then we are celebrating our 100th anniversary as a chamber, which is really fun. We've been around since 1925. So for the first 100 days of this year, we are aiming to get 100 members. And what I wanted to share with you all is that membership for us is a really special thing because Arvada, this community that we've built of businesses and leaders, is a really special one. And I know many of you are already part of that. And so this for us is helping to expand that community and build space for people to be part of it. And so if that's something of interest to you, Paul is in the back and he'd love to share that with you. I also want to take a moment again to thank our friends at AIDA for being here and supporting this work. Excellent partners on this event. And again, thank you for being here. Let us know if you have any questions. We will send out the slide decks digitally as well as the recording if there's someone on your team or in your network that you want to be aware of this. So thank you again for being here. We appreciate you all.
Thanks.
Have a great day.